Assemblyman Chavez. Item number 12, please. AB 1802. We got you moving all over today.
Well, after hearing that, good afternoon. I have a bill that non-lawyers can actually understand. Leno, that was for you, by the way. The Victims' Compensation Program was created in 1965, the first such program in the country. The Victims' Compensation Government Claim Board provides compensation for victims of violent crimes. In 2015, the Legislative Analyst's Office issued a report on improving this state program for crime victims, where they concluded, among other findings, that the Crime Victim Compensation and Government Claims Board needed to be restructured in order to better focus on victims from programs. AB 1802 adds 2 members to the Crime Victim Compensation Government Claim Board who would be appointed by the governor. One of them would be a member who serves as an expert in victims' rights and advocacy that possesses education and 2 years' work experience in social work or victim advocacy. The second member would serve as a physician, psychiatrist, or psychologist with expertise in treating and providing services for crime victims. By adding 2 members of the board that are experienced in these unique issues, victims will have appropriate representation. This is being supported by the Crime Victims United of California. We've dealt with a number of advocates in this area and believe we addressed all the issues, and I request your aye support.
Witnesses in support.
Nope.
Well, I was asking if the audience wanted to come up. Do we have any witnesses in opposition?
My name is Lucy Salcido Carter. I'm with the Northern California Innocence Project, and I want to make some comments to you representing both our organization and the California Innocence Project. My colleague had to leave. We have worked to free 18 wrongfully convicted, innocent people from prison. They have spent over 230 years collectively in prison. The harms to them are immeasurable. California has compensation laws that can at least partially remedy the harm to them. They are entitled to $140 a day for their time wrongfully incarcerated. This board that makes compensation decisions for crime victims also makes compensation decisions for exonerees. We really recognize the value of having crime victim experts on this board, but there are no exoneree experts on this board. So we are opposing, unless amended, because we really would like for there also to be added some expertise related to exonerees and wrongful convictions. The wrongfully convicted have already lost years of their lives, decades sometimes. And we really think that they deserve an informed decision-making body that can make decisions regarding compensation for them so that they can move on with their lives. Thank you.
Assemblyman, would you like to address that issue at all?
Actually, I agree with her. You know, this issue of the Innocent Project was just brought up a few days ago. We've been at this for some months now. We met with them and we're looking at how we could craft this in a way, because as you mentioned, the numbers are so small and this board meets all the time. How could we best represent them? We talked about having a partial board member whenever you have an innocent person come forward where they would be on the board, you know, so we're looking at but right now we're running into language issues on can you have a partial board member or a member only on the board for a period of time. So this was just recently brought up and I'm willing to work with her. I think she brought up a very good point. But right now we have this before us and I'd still request your high support. And I'm more than willing to work with her because I think she brought up a very good issue that needs to be recognized.
Thank you. Members, do you have any questions? Perhaps a motion? Senator Leno.
Senator Anderson, as you and I have worked on any number of bills that deal with victims of the state who have been wrongfully incarcerated. And I'm so pleased to hear the author very open to this. We're just checking if there is another stop this bill makes. Does it go to appropriations?
Appropriations.
It does. Okay. I understand, number one, thank you for being open to it because it is a real issue. And I have different numbers in my head. I'm not sure if it's only 11 out of 132 exonerees have actually gotten their $100, now $140 per day. It's somewhere in that neighborhood. It's a really small number, and it's just wrong. And I don't understand all of the reasons and all of the hurdles that are in their way, and we've done some legislation actually to clear the path so that those who have been identified as wrongly incarcerated can get what the state owes them. And given that this is the board that makes the decision, their voice needs to be heard.
I agree.
So one way or the other, I'd like to believe I'm going to support the bill today.
Thank you.
But for me to support it on the floor, I would expect to see this issue one way or the other, directly, indirectly, whether it's a part-time for those issues when they get to the commission, get to the board, or if there's a requirement that there be some consultation with an expert, something to make sure that that voice is heard, because unfortunately right now it's just not, and too many people due their compensation for having been victimized by the state are not getting it. So it'd be easy enough for us to say, well, that's good for another bill another time, except we don't make changes to this board all that often. I think this is a good opportunity, and I know that you're not resisting, so it's just a matter of getting it done before it gets to the floor.
Senator Leno, if you don't mind me asking, looking at somebody to come in and give testimony, would that fit in the realm if that was a possible solution in your mind for your on the floor?
So the analysis suggests that as an alternative to the idea that there be a part-time, as the Assemblyman has mentioned, that the board be required to consult with or retain an expert in wrongful conviction and incarceration of the innocent that would present testimony. So I'd want to hear more, not necessarily at this moment, from the Innocence Project to see how we can be most effective in getting that voice heard.
But you're not married to one way of...
No, I am not.
Okay. Senator Stone, did you have a question? All right. Were you somebody making the motion?
I'll make the motion, and of course, as I've already stated, my vote is with the understanding that there'll be some changes by the time it gets to the floor.
Assembly member, would you like to close?
I'd just like to close and thank for the discussion. You know, as you go through these policies, you actually learn a lot. And when I heard about the Innocent Project discussion yesterday, I said, I actually agree with them. So happy to do it. We'll make the amendment.
Thank you.
Well, with that said, this is due pass to appropriations. May we have a roll call vote?
Anderson?
Aye.
Anderson, aye. Leno? Aye. Leno, aye. Monning? Aye. Monning, aye. Stone? Aye. Stone, aye.
Garcia's next. Your bill's going to go on call, so other members may add on.
Thank you very much, sir.
Thank you. Assemblywoman Garcia, would you present item 2, AB 701, please?
She's got amendments.
Yeah, sure.
Good afternoon. I want to start by thanking the committee staff and the chairwoman for working on this bill and helping draft a set of amendments that I will be taking up as author amendments. Really appreciate it, given the large load of work you have on your plate. And this should also remove the opposition by the ACLU. AB 701 modernizes California law to reflect that any sexual penetration without consent is rape. Under current law, rape is limited to an act of sexual intercourse or heterosexual sex. Other types of sexual assaults, including forcible acts of sexual penetration by a foreign object and sodomy, are defined and categorized as different crimes. California's restrictive definition of rape means a man cannot be raped by another man. It means a victim who was forced to engage in oral sex was not raped, and it means that being sexually penetrated with foreign objects is not rape. While these actions may not fit into the traditional definition of intercourse, the emotional and mental harm are just the same. California law shows a bias against lesbian, gay, bisexual, transgender, and questioning victims. This is especially unjust given the staggering statistics which show that the LGBTQ individuals are more likely to be victims of sexual violence than heterosexuals. AB 701 makes it clear that any non-consensual sexual penetration is rape, because when we fail to call rape rape, we rob the survivors and their families of the justice they deserve. If we are going to truly be committed to ending the rape culture, we need to start calling rape what it is. The bill has no opposition, and I respectfully ask for an aye vote.
Thank you. Speakers in support of the bill?
Madam Chair, members, Dan Filizato on behalf of the Los Angeles District Attorney's Office and the California District Attorney's California District Attorney's Association. It's a long day.
I'm glad somebody besides me is doing this.
We would like to thank the author, the staff, committee staff, for working on this issue with us to get to language that addresses the issue of who is the victim of rape. The Assemblywoman is right. It doesn't matter which type of sexual assault we're discussing. These are all victims and should be treated as such. This bill will help not only with victims doing their victim impact statements in court, but will also help victims in the California Victim Compensation Program. For those reasons, we respectfully ask for an aye vote.
Are there other speakers in support of the bill? Are there speakers in opposition to the bill? Seeing and hearing none, I really want to thank both of you, the author, for working with law enforcement and vice versa. I think we have come up with a very good bill, and thank you both so much. Senator Anderson.
If, since you're taking amendments, I'd like to be added as a co-author, and also I'd like to move the bill.
Thank you, definitely.
Madam Chair, as amended?
You would like to be a co-author?
No, move the bill as amended.
The bill is
okay.
amended, yes, we're taking the amendment.
Yes, as amended. And, well, I would like to be added as a co-author, too.
Thank you.
Assemblywoman. Senator Anderson and I try to co-author as many bills as possible. Anyway.
And you were absent, but you thanked us, but again, I want to thank the committee and yourself for helping us. This was a team effort, and really appreciate the last-minute hustle that we put you in. I want to recognize that. Thank you.
Madam Chair, I'm sorry.
Yes?
If the Assemblywoman will have me, I would like to be as a co-author.
Yes, I would love to have you all.
Question.
Senator Stone.
Mr. Stone.
Yeah, if I could just ask a question of our district attorney representative from LA County, my friend. In a case of a sexual assault where you have sodomy, oral copulation, genital penetration, as a district attorney, is that 3 counts that you can file right now under the present definitions that would enhance a penalty? And by narrowing this down to 1, which I certainly understand and support, are we in any way jeopardizing the full implementation of the remedies that are available to you as a district attorney to file?
As to your first question, yes, those would be 3 separate counts. Those are 3 separate penal code sections. As to your second comment, no, this bill doesn't actually, because it's not a charging or sentencing statute. This in no way impedes the ability of a prosecutor to obtain the just sentence for an individual.
Okay.
This bill will help the victims of these horrible crimes.
Thank you. Madam Chair, if I may, I'd like to be added as well, if the author would so oblige me.
Okay. So the bill has been moved. Yes? Okay, I'm sorry, I missed that. Would you like to close, Assemblywoman?
Respectfully ask for an aye vote.
Thank you. Please leave the room.
Hancock,
Aye.
Hancock, aye. Anderson? Aye. Anderson, aye. Glazer? Leno? Leno, aye. Lou? Monning? Monning, aye. Stone?
Aye.
Stone, aye.
Thank you very much. Chairman Jones Sawyer, item 19. AB 2013.
Thank you. Have you found it yet? I was going to say, you can add me on too, but I think I'm in the wrong house.
Right, don't.
AB 2013, probable cause determination hearings, pilot project. Madam Chair and Senators, AB 2013 is responsive to the governor's veto message on AB 696 from last year that suggests a pilot program be created. Under current law, only misdemeanor defendants in custody are entitled to a ruling by a magistrate at the time of his or her arraignment to determine whether there is probable cause to support a charged offense. This bill establishes a pilot project that would, within a select group of counties, require a court to issue prompt probable cause determination hearings from out-of-custody defendants charged with a misdemeanor. Such a change would save counties time and money by negating the need for prosecutors and defense attorneys to prepare for trial, including the subpoenaing of witnesses, extensive discovery of the opposing party's evidence, and the filing of illegal motions. As the number of misdemeanor cases increases with the passing of Prop 47, and with judicial resources continuing to shrink, the judiciary itself has a vested interest in screening out of-custody misdemeanor cases before they become an unnecessary burden on our trial courts. As a pilot project, AB 2013 is a modest step in ensuring our court's ability to identify and disperse with baseless cases at an early age for the benefit of both the court system and the litigants. I respectfully ask for your aye vote. Here to testify on behalf of the sponsor is Mr. Chuck Denton, President of the California Public Defenders Association.
Good afternoon, Madam Chair, members of the committee. I'm also a public defender in Alameda County, and I thought I would add just a couple of practical observations. The first one is that this bill, I don't think, is going to open the floodgates of litigation and swamp the courts. Currently, we have about 2,000 pending misdemeanor cases in Alameda County. About 20 to 30% of those folks are in custody at the time of arraignment. We do about 7 of these motions a month. That's over 2 courthouses. So even if this bill tripled the number of motions, we'd still be talking about maybe 1 a day spread over 2 courts in a county with 1.5 million people. The other thing is that the people targeted by this bill, the misdemeanor defendant who's out of custody and whose police report reflects that arguably there's not even probable cause, much less proof beyond a reasonable doubt, those are the folks that are most likely to go to trial. And barring some unfortunate event, those are the folks that the public defender and the district attorney are going to spend the most time working their cases up and preparing. And those are the cases whose trajectory, if it is not diverted, short-circuited, or stopped in its tracks, are most likely to end up in a trial court where a court could easily waste a week. So this is kind of an ounce of prevention. 5 to 10, these motions are typically very brief and pretty informal. The judge reads the police report, usually at the recess, so it doesn't even use up court time. It takes argument from the lawyers briefly, and then she makes her findings. And that's it. It typically takes between 5 and 10 minutes, rarely if ever more than that. So for 5 or 10 minutes at the beginning of the case at arraignment, you could be saving a week's worth of time, court time at the end, and considerably more than that in attorney time in preparing. And, you know, the lawyers in Alameda County on both sides, you know, are running caseloads of around 100. So these is not going to change the caseloads significantly. But, you know, believe me, when you have 100 cases, every little bit helps. The last thing is I think that this bill will bring some symmetry to the law. Nearly every other class of litigant has a tool for weeding out groundless and unsupported charges. Civil litigants have the summary judgment process. Felony defendants have the right to a preliminary hearing within 10 court days. Misdemeanor in custody clients get a determination of probable cause under the current law. The only class of litigants that doesn't have a remedy right now is misdemeanants who are out of custody. So if this bill passes, not only do I think we save some time and money, but I think we also close a gap in the law. Thank you.
Thank you. Others in support?
Larry Doyle on behalf of the Conference of California Bar Associations. We support this bill. I think all the bases have been covered in the prior testimony, except to point out that the arguments against extending the 9981 process from a policy standpoint are that the only injury that is suffered is the lack of liberty for the in-custody defendant. But there's an awful lot of injury that takes place just with the idea of criminal prosecution hanging over you. You've been charged with a crime. It seems that the charges are bogus. You'd like a quick determination to get rid of that, move on with your life. Existing law doesn't provide that. This bill will. It's targeted to try to respond to the governor's concerns. We hope the committee will support it.
Thank you. Are there others in support?
Yeah, Khalif Asagay, California Public Defenders Association. We're the sponsors of the bill. We appreciate the committee's work on the bill, and I'll just associate myself with the testimony of our witnesses. Thank you.
Thank you.
Micah Doctoroff on behalf of the ACLU of California in support.
Dennis Cuevas Romero on behalf of the California Attorneys for Criminal Justice in support.
Thank you. If there are no others in support, are there speakers in opposition to the bill? Please come forward.
Good afternoon, Madam Chair and members. The Judicial Council is regretfully opposed to AB 2013. We certainly appreciate the author's efforts to overcome the governor's veto of the bill that he authored last year, but we remain concerned about the breadth of the pilot study. For example, with the inclusion of the Los Angeles Superior Court, which represents a third of all filings in the state, we're concerned that the impact on the courts could continue to be considerable. With the addition of 5 more courts in the pilot study, that could easily represent over 50% of the filings in the state. So our concerns about the impact on the courts remain. We understand that there are some differences in how the sponsors view the potential impact on the courts and how the Judicial Council is analyzing that. We do have some more on the, I guess, technical side concerns. One concern is about the composition of the committee that would be selecting the pilot counties. I think the council believes that it's probably in the best position to identify the courts that could best absorb the potential new workload. Also, more on the technical end, we think the bill could benefit from clarification about who is responsible for convening the committee, what the deadline would be, et cetera. And then finally, we do have some concerns that the Department of Justice may not be in the position to provide information to the legislature regarding the implementation of the pilot project on those technical matters, and anything else. We're happy to continue to talk to the author's office about these issues, but regretfully at this time the council remains opposed. Thank you.
Thank you.
Madam Chair, members, Dan Filizzato on behalf of the Los Angeles County District Attorney's Office and the California District Attorney Association. We are also regretfully opposed to the bill at this time. I certainly understand the issue that the Assemblyman and the sponsors want to get to, but in Los Angeles County, we filed over 120,000 misdemeanors, very few of which, because of our jail situation, are in custody. And a 991 motion, no matter what everybody else says, the purpose of a 991 motion is to protect against the harm caused by loss of liberty, being incarcerated. By definition, these individuals are out of custody, so there is no deprivation of liberty as what the stated purpose of a 991 motion is. It's our understanding that the author is going to be working while on summer recess. We will gladly continue to work with the author. I have the utmost respect for him. But as it stands right now, like I say, the whole purpose of this bill is completely contrary to what the purpose of a 991 motion is. And given just the overwhelming volume of cases, of which, like I say, in LA County, few, if any, people are in custody, we have concerns. But like I said, we'd be happy to continue to work with the author.
Thank you. Are there others in opposition to the bill? Seeing and hearing none, are there any questions or comments from committee members? Senator Stone?
Thank you, Madam Chair. To our district attorney friend from Los Angeles. So this is basically going to be providing an additional step, an additional hearing, is that right, for district attorneys to have to go to like this quasi-preliminary trial?
It would be, in lay terms, it'd be like a mini prelim with a much more, a much shorter process. I don't mean to think that this.
But it is in addition to what you normally would be doing,
right? Because a 991 motion is only for individuals in custody.
Right, and in Riverside County, we have the same problems that you have in LA County, that our jails are congested, and most of our misdemeanors are out on the street. So in addition to you being there, is it also appropriate that police officers that need to give testimony be there with you during this examination?
That would be up to the court because,
Sure. The preliminary, the 991 motion is based on just the police report and any statements taken, so the police officer doesn't have to be there to establish probable cause for this hearing.
unless the court requests that. But typically, it's supposed to be the four corners of the police report and any addendums, witness statements, anything that was submitted.
Okay, thank you very much.
Okay, I have a couple of questions. Does Los Angeles County not want to be included? Or why was it included? Generally, they're always in every pilot project.
I think, go ahead. I think it may have been that when you do these pilots, you also don't want to get something that's just too large and unmanageable. I mean, the whole purpose of this is to try to find a representative sample so that we can get this done really based on what the governor's wishes. The governor wanted to, or for lack of a better word, he wanted to test drive this to see how this works. And so I believe Los Angeles County may not have been chosen just because of the sheer size of it. It could be maybe unwieldy.
But this bill says that has to be, right?
Yes. And that's, and so LA is in.
That's it. Los Angeles County doesn't wish to be in the bill because, like I say, because of the sheer size, the number of courthouses, the number of cases we file. The governor, his veto message asked for a small, I forget the other term, small, concise.
Representative number.
And Los Angeles County, we're generally not included in most pilot projects because of our sheer size. We are too big.
So if I can help, I'm a firm believer that you need to talk to the individuals who actually will ultimately implement this.
Yeah.
And so I will work with LA County and all the courts to try to come up with a methodology so that we can get the best results at the end, if that answers your question.
No, I think the idea is an excellent idea. And I'm just looking at there's going to be a committee set up, and then they would choose the counties. I would think we would want to choose counties that just wanted to give it a try because they could see it as a way of expediting things in the long term.
Madam Chair, we, as a sponsor, are going to be in conversations with other counties, our public defenders' offices, as well as the Appropriations Committee moving forward to find which counties this would best work in. We're thinking about potentially narrowing the scope of the pilot project to address those concerns, and so we'll be in ongoing conversations during July to see what the best composition will be moving forward. I mean, you all supported this bill last year when it was statewide, and I do think that having a representative sample looking at Los Angeles County as a target means that we get the greatest bang for our buck during this trial period. That's why our association strongly wants to include Los Angeles County, because there are so many filings there, there is so much overcrowding there, and it would be such a benefit to our attorneys. I think the other thing I would add, based on the concern about the time that this might take, is that this is not prescriptive, but it's optional. And defense attorneys are only going to bring 991 motions when they are to a certainty of about 99.9% that they'll be granted, because if not, when arguing the motion, they'll be revealing their theory of defense. And so it's unlikely that people will use this in a frivolous manner, and also there are sanctions associated with it. So regardless of the size of the county, if and when these motions are brought and they're granted by the court, we will be saving time and resources, but we are sensitive to the issues that have been brought up and look forward to working with these other organizations as we move forward.
For example, I was just thinking, as in with the LEAD program, sometimes you do a carve-out. There could be a carve-out of some particular area in LA or whatever, because in Seattle, when they piloted the LEAD project, it was only in one part of the community. And I know some of the interest that's been expressed to me from other jurisdictions has been even a couple of cities with one overlapping area. So anyway, many ways to cut the cake, but I think it's a very good bill. And are there questions or comments from members of the committee, or is there a motion? Bill's been moved. It's due pass to appropriations. Please read the roll. Oh, would you like to close?
I respectfully ask for an aye vote.
Hancock?
Aye.
Hancock, aye. Anderson? No. Anderson, no. Glazer? Leno? Aye. Leno, aye. Lou? Lou, aye. Monning? Stone? Stone, no.
Okay, I'll hold the roll open for the absent members. The vote is 3-2.
Thank you.
Yes, thank you. Okay. Assembly Member Stone. Welcome to the committee.